Excuse me, counsel, can you tell me how to pronounce your client's name?
TWOHEY, Craig TWOHEY.
Thank you.
Okay, hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Single Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. The case is 22J26. Craig TWOHEY versus Pamela Ryan et al.
Good morning, everyone. I am Justice Sabita Singh. I will be presiding over this hearing. I will first hear from the appealing parties, the defendants, the Ryans. Please go ahead and let me know your position.
Yes, Your Honor. I'm here today with the hope that the judge should waive the appeal bond and the monthly installments. Due to the fact that the plaintiff misrepresented the property to the court and therefore got a bad market value of the property. By plaintiff's own admission, the septic system is not on the property. It's on my wife and I's property. It took 8 years and about $80,000 to obtain this piece of property. Plaintiff also admits that there's a defective title due to the fact that he could not get a conventional mortgage. And I have exhibit B and C. The property does not meet the requirements for a rental property in its current condition. The market analysis that I provided is with all of the deficiencies that exist with the property. There is a defective title system. It does not meet the requirements of Title V. Oh, geez. A house without my septic system does not meet the minimum requirements for habitability. I'm only going by what the health department said. I also submitted that as an exhibit. The market analysis that I provided, 21, Exhibit E, parcel is not a legal conforming lot. And whatever the appraised value of the home, mine was from 2014. It was appraised at $215,000.
Sorry, 215,000?
Yes, ma'am.
Oh, yes.
And the damages, according to my market analysis, was $215,000. Now, if it goes up, the damages go up. And then the owner, the potential owner, and the attorney are both aware of all these discrepancies, all the deficiencies of the property. Craig TWOHEY's attorney misrepresented the property to the court. The same way the bank misrepresented the property to my wife and I at our closing, May 30th, 2003. They're aware of all of the problems submitted by the court. I already mentioned that. I have case law that I didn't submit, but I came across it last night. Bank of New York versus Apollos, APOLLOS, 208 Mass. mass.app.div.208. This case law says you can't get a bond and rent at the same time. To be honest with you, I don't think I can get a bond for $20,800. That would basically put me into bankruptcy. $22,800.
Sir, could
I'm
you
just asking.
give me that
Yes, sir.
citation again?
Bank of New York versus Apollos, Apollos, 208, Mass. 2008, mass.app.div.208. It's out of New York, the Bank of New York.
Thank you.
But getting this appeal bond, I don't think I can get it because of my credit score, the amount of money. I'm beneath both my cars. I don't know where I'm going to get it. It would drain. It forced me into bankruptcy.
Well, sir, from the papers that I looked at, it seems that the judge first found that you were not indigent, although you didn't file an affidavit. It was through your testimony, and secondarily found that you didn't really have a good ground of appeal. So, on the question of indigency, do you have anything to say about that? Whether the judge was right or wrong to determine that you were not indigent?
I don't recall him saying that. I never brought it up. No, it was, he wanted $67,000 originally. Then I received paperwork for $22,800 and $1,200 a month. But the fact is, Attorney Glennie misrepresented the property. There are deficiencies with the property.
Well, can I ask you, how did the judge come up with the $1,200 figure for the monthly use and occupancy?
Well, this is all new. He never saw any of this. I had I received the market analysis on Friday at 10:30 at night when I got home from work. The hearing was on Monday. I got caught off guard. William Curley was an independent market analysis. He clearly explains the deficiencies, and they still exist today. They existed in 2003, 2014, 2022. All these deficiencies to the property still exist.
It sounded to me as if the judge had come up with that number by looking at the mortgage payments. Is that accurate? That the mortgage payments were about $1,200 or something around there?
My mortgage payments were $817 a month. I put I put every penny I had down. I got caught off guard. I'm pro se. I represent myself. I was running around, my head cut off. It took me 3 days to find this market analysis in the basement. And I didn't even find it. My wife did. I mean, the fact is, Judge, he misrepresented the property. The last judge didn't see the market analysis that I have with the deficiencies. I mean, I spent 8 years and $80,000 getting a strip of land for the septic.
Okay, so your argument regarding the misrepresentations, I think, go to the amount that was set as the bond. What I'm looking at are the two issues that are before me, and I think as to the first, whether you're indigent or not, the judge indicated that he came to that determination based on asking you questions. I don't really have that information in front of me, but the second issue has to do with your grounds for appeal. In the papers that you filed in the appeals court, it sounds like you're indicating that your grounds for appeal are that you have 2 cases pending on appeal regarding the title to property, and that you believe that you will succeed. My understanding is that there was a superior court action where you did not succeed at the trial level. It was appealed to the appeals court, and my understanding is that that judgment was affirmed in the sense that you did not succeed in the Superior Court action. I also have an
Correct.
understanding that that there is a land court action in which you did not succeed, but the grounds for that was that it was the same issue that was litigated in the Superior Court action, and on that basis, you did not succeed in the land court. I understand that you appealed from that, and that appeal is still pending. It sounds to me that the appeal would relate only to whether the judge, the land court judge correctly determined that it was really the same issue that was raised in the Superior Court. Is that your understanding of what's left on appeal in the land court action?
Well, in the Superior Court, I never argued foreclosure. They're saying I've already argued a foreclosure. The two attorneys in Worcester Superior Court, June 5th, 2018, one of the attorneys said the auction had fallen through. The other attorney said the auction failed. Now, how am I going to argue something that doesn't even exist? But they said I did argue it, and I'm arguing statements of fact, not arguing case law. It was misrepresented by everyone. Judge Mulqueen clearly states in her paperwork, she did not rule on the third paragraph of counterclaim count 1. And let's say she did rule on it. He clearly states the bank has the right and the authority to foreclose. But at that time, there was no foreclosure. Both attorneys that represented the bank stated that in court. So how can I argue something that doesn't even exist?
Okay, thank you.
All right.
I'm sorry, Mr. Ryan, I don't want to cut you off, but
Yep.
but I think that I do have your position. I will come back to you, but at this point, I want to give the attorney an opportunity to represent his client's interests. Counsel.
Okay.
Thank you, Your Honor. First of all, I just have to say that the recitation that Mr. Ryan gave has many misstatements in it. As far as him accusing me of misrepresentation to the court, I obviously have to state my objection to that. I don't want to get too far in the weeds on the merits. However, the housing court judge specifically stated in his decision that he looked at the opposition that the Ryans presented that had this whole septic issue part of it. It was attached to it. Mr. Ryan even testified about that issue during the court hearing, which is why I believe the judge probably cut our request down in half, because we had the only affidavit supplied as to what the fair rental value of this property was. The septic system is not part of what was foreclosed on this property. That is correct. It sits on a separate piece of land that the Ryans own. Everybody knows that. That's not at issue. There are septic design plans that have been approved by the town, however, that can sit a septic system on the parcel that has been foreclosed. So just so that we're clear as to what Mr. Ryan's talking about. Now, the statute requires a bond unless they can prove that there's a case of indigency and that their appeal is non-frivolous. Indigency is defined by Chapter 261(27)(a) and has specific requirements in order to be indigent. The Ryans have produced nothing, no affidavit, no financial statements, no bank records, nothing that shows them that they're indigent or their financial status in any regards. They testified at the hearing before the housing court judge regarding the appeal bond that they both work. They testified that they have not made a mortgage payment since March of 2013. So we believe that they're not indigent. The second part is the non-frivolous of the appeal. The Ryans in this case are claiming that the foreclosure is defective. That is the same claim they made in 2017 in the Superior Court action. It's true, It was a 93A claim against the lender, and there was a fraud claim against the lender. But it was all based on the foreclosure. In fact, they specifically pled that GFA pursued, quote, a foreclosure of a knowingly defective mortgage. GFA filed counterclaims, and they also filed, as part of one of their counterclaims, an action to quiet title based upon the foreclosure. GFA was allowed summary judgment. The Ryans appealed, they lost that appeal, and further appellate review was denied. The Ryans then filed an action in land court in November of 2020. There they alleged that the foreclosure was flawed because GFA didn't own the note and mortgage. GFA and Mr. TWOHEY moved for summary judgment, and it was allowed based on res judicata, that you have to bring all of your evidence, all of your arguments for the same claim. And they were allowed summary judgment in the land court. They have now appealed that to the appellate court. They're making the same argument on the summary process action in the land court. They're saying that the foreclosure was no good. The appeal is futile. They're barred by res judicata. This is the very reason why we have res judicata. So they can't keep making the same claim, but bringing up different factual allegations or different evidence. That's the whole reason why we have res judicata, Your Honor. The appeal is futile, and they don't meet the standards. As far as the award that was given for the bond, I suggest that, yes, this is a house that if Mr. TWOHEY purchases it, he's going to need to install a septic system. But the fact remains that the Ryans are in that house. It's connected to a septic system that's on their other property, but they are in that house, and they are depriving Mr. TWOHEY the use of that house. And I believe that's why if the house had its own septic system, it's $2,400 based on our affidavit that was supplied. I believe that's why the judge cut it in half.
Okay, thank you. And again, I'll turn to the Ryans on any response. And again, if you could just focus in on the two issues that are really before me are whether the judge was correct to find that you are not indigent, and whether the judge was correct in determining this bond amount.
Once again,
Is there any,
Attorney
I have heard your initial arguments. You don't need to respond, but I'd like to give you a
Okay.
chance to respond further.
I'm just saying Keith Glennie is assuming that the septic system is working. I mean, under the health department, you can't even rent it. It doesn't meet the minimum standards to rent by itself. He's saying, well, once we get it, we're going to put a septic. Well, that's not the case right now. The case is it's not on his property. He's assuming, oh, well, we're going to take care of it. Well, when you take care of it, then you can rent it. That's if you win. If I lose in the appeals court, and you have to alter our property. But I was unaware, like on that hearing, I had $1,000 in the bank. I went to a bank to try and get credit. They won't give it to me. And it would force me into bankruptcy, this bond. There's no way in heck I can do it. I don't know anybody that had $22,000 in the bank. That's, I'm using one of the case laws will say you can't get both. You can only get one or the other. That's the case. I can request appeal bond for Craig TWOHEY because his septic, the septic is on my property for the use. I can charge him for the use of my land.
Okay, sir, thank you. I want to thank the Ryans. Thank you, counsel. I think I have both of your positions. I will take the matter under advisement and the parties will be notified.
Thank you, Your Honor.
Thank you. Thank you, Your Honor.